Welcome, everybody. This is a fantastic turnout. I appreciate your being willing to come on Zoom in light of the Omicron and are not wanting to spread anything to each other. And hopefully everybody is well. Today's schedule, which of course you can't see, we will begin with prayer by David. Then Andy will introduce Lauren, who will talk about what you need to know for estate planning. We'll have time for questions and answers. Following Lauren's presentation, Elaine Wilson will have a minute for Meals on Wheels. And then we'll discuss upcoming programs and closing thoughts. So David, I don't see you. Are you here?
Yes, I am. Good morning.
Will you lead us in prayer, please?
Absolutely. I had to go get a COVID test, just part of our weekly clergy, and then took much longer than I expected. So I had to pull over before I could head back home or to church. So I'm in my car. So let's pray. Gracious
Can you
and
pray
loving
while
God,
you're driving?
Oh, I stopped the car.
Okay.
Let us pray. Gracious and loving God, we give you thanks, O Lord, for this day. On this bright, sunny, and warmer January day, we are grateful, Lord, that your sun continues to warm us, and that your light continues to shine and lead and guide our path. May you, O Lord, be with us this day as we gather now, and with our speakers who will speak to matters of plannings and financial matters. We ask, O Lord, that you guide her in her sharing the information, and may what we receive this day, Lord, help us and continue to bless this ministry of third age and for all the senior adult ministry here at Westminster. We thank you, God, for the committee leadership and for Rachel's leadership as well, and ask, God, that you watch over all who support this ministry. And this we pray in your name. Amen.
Amen.
Amen. Andy.
Alrighty. Lauren Fink is an attorney with Master Amundson Boggio. Did you get that right?
Yep.
Practicing in their elder law department. She assists her clients on the implementation of estate, long-term care planning, special needs, and business succession plans. Lauren chose to become an attorney after observing the difficulties her parents faced as caretakers for elders in her family. She wanted the tools to be a valued guide for others in the same situation. We are very pleased to have Lauren here today to share her expertise. Lauren, I would also like to express my appreciation for your efforts and flexibility as we make changes in the last minute here to make this presentation happen. With a special shout out to Cynthia Johnson from your firm, who did a great job in the background, kind of coordinating everything. As I told you earlier, your firm excels in the positive first impressions category. And with that, I'll turn things over to you to begin.
Thanks, Andy, and thanks everyone for having me here today to talk to you all. I'm excited to share some information, and I hope that you all take something away from it. I am gonna get my screen going here so that I can share the slides. So here we go. All right, so the topic that I am going to speak to you all today is about planning your legacy. So we'll be talking about what you need to know about estate planning. There we go. And Andy introduced me a little bit, but just a little bit more information about my firm. The name of my law firm is Amundson Boggio, and we are an elder law firm. We're located in Richfield, Minnesota. We have been around for over 30 years, and we focus on elder law. So elder law is a particular area of practice that focuses on issues that pertain to seniors. We also do special needs planning. So I just have a listing there of all of the different practice areas that we focus on. Today, we'll focus sort of what the objectives for the lecture are to learn about what the different options are for planning your estate, to examine the pros and cons of each option, and then also to discuss some common mistakes to avoid in estate planning. So one of the first things that I'd like to examine with all of you is the question about who needs to plan. Because there's always some, when we use the word estate planning, it always seems very overwhelming and we think, oh, well, I may not have an estate to plan for. But I think if we look at the first question that I have on here, are you over the age of 18? I think I can comfortably say that everybody that I saw on the screen when we were all sharing appears to be over the age of 18. Not a lot of people who are under 18 enjoy attending lectures about estate planning. And I say that from the perspective of 18 is the age where Minnesota says that you have reached the age of majority. And that's a time frame where your parents can no longer make decisions for you as your legal guardian. So even when we think about people who are turning 18 and graduating from high school, there's a little bit of estate planning that needs to happen there in terms of possibly appointing substitute decision makers under a power of attorney or a healthcare directive. If something happens to your 18-year-old, what are you going to do if they get into an accident or into a situation where you now need to step in and make decisions for them? Are there ways that we can make that simpler or have that planned ahead? Do you need to plan to minimize exposure to estate taxes? We're going to delve into estate taxes for Minnesota and for the federal government and what that looks like. And the answer about whether you need to plan for it might be yes, when you don't think it might be, when we talk about what all is composed of a taxable estate. Do you have a family member that has special needs? Individuals with special needs are often recipients of means-tested government benefit programs, which they need in order to help them make sure that their needs are being met or they're being assisted with their activities of daily living. And if they receive an inheritance, that might affect their ability to receive those services. So there may be some extra planning within your estate plan to ensure that they're not negatively affected by the gift that you leave to them. Do you have real property in more than one state? If you have real property in more than one state, if you don't have a plan in place, then you might have an expensive administration. So there are ways that we can set up that real property to save costs and expenses for your family after you're gone. Did you recently get married or divorced? Have you had a life change, which has now changed the way that you want your assets to be distributed, or that changes the people that you've named in your documents if there's any period of incapacity who can act for you? Anytime that we have big life changes, it's a good idea to sit back and take a look at our estate planning documents and see whether they're still accomplishing the goals that we set forth when we initially drafted them. Do you have charitable objectives that are important to you? Do you want to give back after your death? Or do you have some goals to give funds to charity during your life? There are really good ways of doing that. And there are ways that are not so great to do that. So, looking at that and making conscious decisions about charitable giving is a great idea when you're looking at your estate plan. Do you have children from a prior marriage? If you don't have an estate plan set up, then I always like to say that the state of Minnesota has an estate plan set up for you. The state has default provisions if you have not planned for your estate, where your assets would go. And your marital status, whether you have children from the marriage that you have now or whether you have children from a previous marriage, affects the distribution of your assets. And the way that Minnesota has planned your estate may not be the way that you want your estate to be distributed. So it's important to review and ensure that your property is going to go where you want it to go. Will your family members agree on your end of life care? If you are incapacitated and there are conversations about withdrawing hydration and nutrition or do not resuscitate or those different types of hard questions that can come up, are all your family members aware of what your wishes are? And have you taken a step to get those wishes in a legal document where they would be enforceable so that it can reduce fighting if there are disagreements about what would happen after you're gone. Do your retirement plan and your estate plan lack coordination? Do you have beneficiary designations on your IRAs that say something completely different than your will or your trust or your other estate planning documents say? It's important to always make sure that everything that you have set up, even if it's a beneficiary designation, those are part of an estate plan. And we want to make sure that they're all going in the same direction, and that they all are tied together and are accomplishing what your wishes are. And then lastly, do you have a diagnosis that may require long-term care? Long-term care is always kind of the gorilla in the room that throws up the cards that we've set up carefully for planning. And if you have a diagnosis, then it may be a time to review what the plan is that you have in place and talk about whether there's any changes that need to be made based on the changes that you've experienced with your health. So I want to turn to talk about some common planning techniques, and we're going to go through each one of these individually. So we're going to talk about doing nothing, owning property jointly, designating a beneficiary, signing a will, revocable living trusts, and then we'll review some incapacity documents such as powers of attorney and healthcare directives. So doing nothing. Doing nothing is the default estate plan that we're all born with. Nobody has an estate plan when they're born, and if you don't do anything, you still have that same estate plan. And I mentioned earlier, if you don't have an estate plan, the state of Minnesota has an estate plan for you. So the state has what is called intestacy statutes, and intestacy statutes line out if you die, and depending on if you are married or if you're single or if you have children, and if those children are from a current or from a prior marriage, that dictates where your assets are going to be distributed after your death. And there's a lack of control there because the defaults that are set by Minnesota may not necessarily be what you want to have happen with your assets. And I have a picture of Prince on the screen here because Prince is kind of the biggest example of a famous Minnesota resident that we have that his estate plan was doing nothing. He died in 2016. And his estate is still being administered through the Carver County Probate Court. And because of his lack of planning, he has a tax dispute right now with the Internal Revenue Service where they're disputing what the size of his estate was. The IRS is saying that he was worth $163 million. And they are saying that he's going to owe around $64 million in taxes, plus an additional $6.4 million undervaluation penalty. Another thing I want to mention is that so far, the lawyers that have been managing Prince's estate have been paid about $10 million in legal fees. So when I think about how exponential that is, and Prince's estate certainly would not have been a simple estate to administer, but if there had been some more planning in place by him, it certainly wouldn't have been a public affair, which is what it's become. And it would have been more defined. I think if you're not familiar with what's happened so far in his estate, there was a dispute over who his heirs were at the beginning of his estate because he didn't have a planning document that defined, here's who the people are that are going to receive my assets after my death. So I bring him up. He's a great example of here's a worst case scenario if we don't have any planning in place. Another estate planning tool that we very frequently see and that many of you may have is joint ownership of assets. Now, it doesn't seem like this is an estate plan, but it is because joint ownership with rights of survivorship dictates where that account is going to go on the death of one of the owners. And I always like to say that joint ownership is a game of survivorship, where the last owner on the account standing wins. Assets that are jointly titled with someone else do not go through the probate process. And so it can be a really great tool for people that are married because you don't have to send that property through any kind of formal process. After your death, you contact the financial institution and you provide a death certificate, and then the account can transfer over into the survivor's name. So it's easy, it's free to accomplish. You just contact your financial institution to get the accounts established that way. But the downsides of it is that it's not controlled by your will or your trust. So I usually like to take a quiz, but I think it's going to be hard to have the people vote when we're doing a Zoom call. But if you have a will, your will does not govern property that is owned by joint ownership. The account ownership trumps. So this kind of goes to making sure that your plans coordinate with one another. I've had circumstances where I've had a client's child call where after the death of the client, their sibling was listed as a joint owner on the checking account that was in the name of their mom. And the mom's intention in her will was to have everything be equally divided amongst the children. And the sibling, after the death of the parent, said, well, I'm not going to split the money that's in here. I was joint on the account and I'm entitled to those assets. And unfortunately, that sibling is correct. If accounts are set up that way, and if it's not specifically distributed within the will saying this bank account at this financial institution is intended to go to both of my children, then it does go to the surviving person who's named on the account. So it's not always a great idea to add a child or non-spouse onto a bank account, not only because then they end up with it and they have no obligation to share that account if that's what your intention is. The other issue is that is ownership of that account. So if the person that you add as a joint owner onto your bank account has any creditor issues, any divorce or bankruptcy or anything like that, then those outside occurrences could potentially affect your account. So you can add a person on as an authorized signer to an account. You can have them named under a power of attorney, and they can have access to that account. But I usually don't recommend anyone other than a spouse being named as a joint on a bank account. And it does, joint ownership avoids probate, but it does not avoid taxation. So if you have an estate that would be potentially subject to estate taxes, joint ownership is potentially going to cause an issue with your ability to claim all exemptions that you may be entitled to. Something that's very similar to joint ownership is beneficiary designations. And we're all probably quite familiar with this from if you have a retirement account that you received through an employer and you started the account opening paperwork, you probably named beneficiaries on those accounts. And those assets do not go through the probate process. The person who is named as the beneficiary, unlike joint ownership, does not have any control or access to the funds that are in that bank account. And on your death, they have the ability to contact the financial institution and then collect that asset. So examples would be bank accounts have what's called payable on death designations. If it's an investment account, it's called transfer on death. In Minnesota, since 2008, we have the ability on real estate to add a beneficiary designation through what's called a transfer on death deed. And there is also another type of real estate interest called a life estate, which adds a beneficiary, avoids the probate process, but on a little bit more of a permanent basis. So all of these methods are ways that probate can be avoided, and you can name beneficiaries, and it's all revocable with the exception of the life estate. Life estates are not revocable. The person that you name as the beneficiary has to convey that interest back to you. So with simple estates, if you have not a large amount of cumulative assets, and you have very simple goals. You just want everything to go outright to the heirs of your estate, and you have not that many people that you want it to be distributed to. Sometimes just using beneficiary designations can be a great and simple, easy way of passing on your assets. If the problem with beneficiary designations come in, it doesn't protect your spouse. So beneficiary designations might not be a great way to plan if you have a second marriage, or if there's a circumstance where the surviving spouse gets remarried. Minnesota has certain elections that when you are married to someone, there are amounts that you can claim against your spouse's estate. So there's minimum amounts that you're entitled to receive. Those elections can be waived if you execute a prenuptial agreement prior to the time that you get married. But if there is not a prenuptial agreement in place, and if you're married, your spouse dies, you leave everything to your surviving spouse and they get remarried, and the surviving spouse then passes away, some of the funds may pass on to that new spouse and not be directed to your joint children, or where you have mutually agreed upon with your spouse prior to your death. So that's sort of what we're talking about when I say it doesn't protect your spouse. It does not protect and care for children. If you have minor children in particular named as beneficiaries on accounts, minors do not have the ability to inherit property. What will typically happen if someone under the age of 18 is named as a beneficiary is that a guardianship or a conservatorship proceeding will need to be instituted. So that's a court proceeding where someone will have to be appointed as the conservator for that minor beneficiary. And it can be time consuming, it can be expensive. So there are much better ways of passing assets on to minor children if that is your goal. It does not provide for special needs beneficiaries. There are really great ways that we'll talk about today that we can pass assets on to individuals who have special needs. Beneficiary designations are not one of those great ways. And it's also governed by a plan document that's created by the financial institution, which basically limits your control. And what that means is that the financial institution says, here's how property that is titled to beneficiaries is going to pass on to them. And it will also define if one of those beneficiaries predeceases you, where that asset will go. And you don't have the ability, similarly to how you do with a will or with a trust, to sort of plan down the line on those beneficiaries. The financial institution is the one who has the ability to say what happens. So those are kind of the downsides of beneficiary designations. So I've mentioned probate a couple of times, and something that I want to talk about is what kind of assets go through the probate process and what kind of assets do not go through the probate process. So on the right-hand side of the screen, we've talked through joint property and property that has beneficiary designations are not subject to the probate process. Property that is titled into the name of a trust does not go through the probate process. And then in Minnesota, we have what's called a small estates limit. And the small estates limit is $75,000. And what that means is if the cumulative amount of property that you have that would otherwise go through the probate process, if it's less than $75,000, then you don't have to initiate a probate. There's a small claims process that can happen where you basically fill out an affidavit and go financial institution to financial institution to collect those assets. But I'll note you generally don't want to rely on that as an estate plan, but it is kind of a saving grace to avoid having to go through probate. Property that has to go through probate is property that is individually titled in your name, that doesn't have a joint owner, that doesn't have a beneficiary designation. I like to say that if we don't know where it's going to go after your death, then it has to go through probate so that we can get a court to bless this is where this asset is supposed to be distributed. Real estate, even if the real estate is valued under $75,000, real estate has to go through probate if it does not name a beneficiary or a joint owner. And then assets that are greater than $75,000. If it's over that number and we don't know where it's going to go, then we have to go to probate in order to figure that out. So what's probate? Probate is a process, it's a court process where if you have a will, then the person that you have nominated in your will as personal representative or executor petitions the court to be appointed. They file your will with the court. And there may be a hearing. In Minnesota, we have a process called informal probate, which doesn't typically require a hearing. Their job then becomes they have to gather together all of your assets. They have to provide notice to anyone who might be considered an interested party in your estate, which would be the people who are your heirs, your children, or people that you have specifically named in a will to receive a distribution. They inventory and appraise all of your assets and provide that information to the interested parties and beneficiaries. They report everything that they do to the court, and it's a minimum of a 4-month process. But I will share that I have never had a probate take only 4 months. 4 months is the creditor claim period, where from the time that someone is appointed as a personal representative by the court, they have to wait for 4 months for any creditors to come forward with claims against the estate. And if the creditor claim doesn't come within that 4-month period, then it's potentially barred. Probates usually take a little bit longer than that because there's taxes that have to be filed, and taxes are usually filed after a year. So it's generally not an active process the entire time. Probate in Minnesota, we have, we've all heard Susie Orman come and tell everyone that they need to get a trust so that they can avoid having to go through probate because it's the worst thing ever. And I don't agree with her on that. Susie Orman, one thing to keep in mind is that she lives in California, which is a completely different jurisdiction than Minnesota. California, for probates, attorneys have the ability in California to charge a percentage of the value of the estate for fees. We do not have that ability in Minnesota. Attorneys in Minnesota are generally going to charge hourly for whatever work they put into assisting the person who's the personal representative in administering the estate. So in California, a probate with property that would be around $25,000, depending on the attorney, could cost a substantial amount. $250,000 if they're charging 10% could cost $25,000, and there might not be that much to administer the probate. In Minnesota, we can't charge like that, and we have many simplified processes to go through the probate process. Signing a will is another method of setting up your estate. And one common misconception with wills is that they assist in avoiding the probate process. Wills do not avoid the probate process. I like to describe a will as a letter to the judge in the probate process that says, "Dear Judge, here's where I want all of my stuff to go." And the will tells the personal representative in the court where and how to distribute your assets. Wills can be handy because you don't have to retitle your property, but you do need to designate your assets to go through your estate. Because I had talked a little bit earlier, your beneficiary designations trump whatever your will or your estate planning document might say. So if you have a beneficiary designation that says, I want everything to go to my 2 children, but you have a will that disinherits one of those children and you didn't update that beneficiary designation prior to your death, that account is going to those 2 kids, including the one that you have disinherited. So again, it's important to make sure that all of your pieces of your estate plan coordinate together. I mentioned earlier that if you don't have a will, then Minnesota has a plan for you, and that's those intestacy statutes. With a will, there can be a loss of privacy. So through that probate process, I mentioned that there are notice requirements where we have to reach out to people who are under Minnesota statutes considered beneficiaries of your estate or heirs, even if they're not going to receive anything. And we have to reach out to everyone who is named within your will. There's also public notice to allow creditors to come forward and place claims against your estates. And sometimes people are uncomfortable with that. Anything that's filed with a court can also is a public record and is publicly accessible. So you can access the court records now online as of last year, or anyone can call up and request records that are in a probate, and that can be uncomfortable. Another option to planning would be revocable living trusts. And a revocable living trust is a trust that you can change. So I like to think of a trust as a bucket that you can put all of your assets into. And the trust says, here's what's going to happen with my assets during my life, during any period that I'm incapacitated, and after my death. Here's where everything is going to be distributed. So it's sort of like a living, breathing, active will during your life. In a trust, there are different players, or there are different titles. The grantor or the settlor is the creator of the trust. So that's the person that establishes the trust and dictates the terms of it. And it's typically the person whose property is transferred or retitled into the name of the trust. The person who is the trustee is the person who controls the property that's inside of the trust. And with many times in estate planning, if the settlor or the grantor and the trustee are the same person, if you are creating a trust for your estate plan and you are still able to manage your own finances and property, then you are the one that is going to want to be the trustee. So you continue to have access to your funds and continue to have control of your property. But you can name successor trustees within your trust as well, where if you are physically or mentally incapacitated and now you don't have the ability to manage your finances anymore, then you can say, this is the person that's going to step in and make decisions on my behalf. That person might be a family member, it might be a trusted friend, or it might be there are professional fiduciaries or trust companies who can step in and act in those positions. And who you choose depends on what your wishes are, depends on who you're comfortable with acting as a substitute decision maker for you. The third player in a trust is the beneficiary. And for revocable trust planning for estate planning, typically the grantor and the beneficiary are the same person, at least during their lives. So the trust is created and it says, for my life, I'm going to have the ability to get money out of this trust or put money back into it, and I can change it at any time that I want to. You may also have residuary beneficiaries, which would be after my death, then here is where this property is going to be distributed. There are testamentary trusts. Wills can create trusts. A testamentary trust would be one that would crop up from a will after your death. And you can do the same thing in a revocable trust too. You can leave trust property to a beneficiary. One thing to keep in mind with trust planning that's a little bit different than wills is that a trust only controls property that is titled into the name of the trust or that names the trust as the beneficiary. And that process is called funding. If you establish a trust, you're typically also establishing what's called a pour-over will at the same time. A pour-over will I like to describe as the safety net to the rest of your plan, where if you missed retitling some of your property and it ended up having to go through probate, then that pour-over will in the probate is going to say, I have a trust. All of the property that's going through this probate is going to get dumped back into my trust because that's where all of my good planning is. But the goal with trust planning is to avoid having to go through the probate process. And so the process then on creation is to retitle every asset that you have, so that now instead of being in your name individually or jointly titled, it's titled into the name of your trust. It doesn't move that asset from where it's located. You still have those assets or those investments in all of the same locations. It's just now that when you get your bank statement, instead of saying the John Smith bank statement, now it might say John Smith, trustee of the John Smith Revocable Living Trust. And that's how we know that it's governed by the trust. Advantages of a revocable living trust: the management of your assets during any period of incapacity. You can be really specific in your trust about what, where, and how you want your property to be used for if you are not able to manage it yourself. So if you have minor children or dependents, or if you want those assets to be used for the benefit of your spouse while you are incapacitated, you can instruct your trustee, here's what I want to have happen. One of the advantages of the trust compared to a will is that it maintains privacy. The only person that will see the trust or the assets that you have titled into the name of the trust would be you, your trustee, and the beneficiaries, and then presumably whoever you're working with to establish the trust. So it can be a way. Sometimes I have clients where they have a family member that they have excluded, and they know that if we did a will and a probate, that person would get a letter saying, hey, your loved one passed away, but sorry to tell you this, you're not going to get anything from their estate. That can just exacerbate family dynamics that might not already be so positive. A trust, they're not going to get any kind of contact or any kind of communication. So it can smooth things over a little bit better. It controls the dispositions of your assets at death. I talked about that a little bit. It might include tax planning. The disadvantages of a trust is that it can be costly to establish. It does require quite a bit more work on the front end because it requires going through every single asset that you have and ensuring that that is retitled into the name of your trust. And again, that's really important to ensure that we do not have to have a probate process. We don't want to pay to create a trust and then end up in probate court anyway. It can be costly to administer, and that is more from a perspective of if you leave someone a trust, and if it's an irrevocable trust, then there may be tax filings that have to happen with it every year. If you have a revocable living trust, it's typically about the same as administering a will, with the exception that you have to have ongoing maintenance for funding of assets. So if you sell a house and you buy a new house, you have to make sure that that new house is titled into the name of your trust. Or if you close out your bank accounts and move over to a different financial institution, you have to make sure that those new bank accounts are titled into the name of your trust. With will planning, the pros and cons of planning with a will. Wills are easy to establish. You don't have to retitle all of your assets because you've established a will. You do need to make sure that you don't have beneficiary designations on your assets that conflict with the terms of your will. If your will says one thing, you generally want to make sure that all your assets are either going through your estate or say exactly what your will says as well. It's simple during your lifetime. You can update your will and there's no need to go through and review and make sure that you retitle your assets. Wills can also contain provisions for doing estate tax planning. So you can tax plan in both a will or in a trust. The disadvantages is the probate. If you are uncomfortable with probate, then a will is not going to be an option that you're going to want to choose. And the probate administration can sometimes be more expensive than a trust administration. And part of that is that in any probate, there are court fees and filings that happen, and there are those notice requirements where you're filing in a legal newspaper in the county that the probate is occurring in, and those are just additional costs that are not necessary in a trust administration. I talked a little bit about testamentary trusts and trusts for heirs. These can be created by either a will or by a revocable trust. So a trust for an heir or an inherited trust can be set up within your estate plan where you say, on my death, my property is going to pass on to my heirs. And this is how I want that person to receive that property. So in an inherited trust, you can control where, when, why, and how they get the funds that you are leaving to them. And you additionally can say who the trustee of their trust is that's going to be in charge of managing that money for them. So this is, most commonly seen where you might have minor children and you want to leave property to them, and you don't want there to have to be a conservatorship where there's a court proceeding that sets up someone who's going to manage that money for them. Leaving them in inherited trusts give you the ability to say, here's how they're going to get the money. And you can say when they turn this age, then the money is going to be distributed to them outright, because that's the time frame that I'm comfortable with them having control and access to their money. You can dictate in the meantime, if they're under that age, here's who's going to control the property for me during that time frame, and here's how I want them to spend that money. So when we have young children, sometimes we're talking about education expenses can be paid for by them, living expenses. You can really dictate exactly how you want to pass that legacy on. The other advantage of an inherited trust is that it can provide creditor protection. So depending on how you have given the beneficiary access to the funds in their inherited trust, if it's locked down and they only get distributions for certain purposes, then if that beneficiary is sued, if they have to declare bankruptcy, the funds that are in their inherited trust are protected against those outside occurrences. And it's one of the highest levels of protection that we can provide in an inheritance to someone. If assets are in an inherited trust and someone gets divorced, or if they get remarried, the property that's in that inherited trust is protected, because within that trust, you can dictate on that person's death, here's where it's going to go, and no one outside is going to have access to those funds. And it's not considered marital property for divorce, where half of that property won't potentially go walking away with that ex-spouse. Inherited trusts are also a really great tool to use if we need to protect the beneficiary from themselves. So if we have beneficiaries who are just financially irresponsible, or if we have beneficiaries who have substance abuse issues, then we can still leave them an inheritance, but we can do it in a way that is not going to cause them to just make a lot of bad decisions that we wouldn't necessarily agree with or want to see them going through. And trusts for heirs can also protect against estate taxes, depending on how the trust is set up. So it's a really great tool to use within your estate plan. The other thing that I had mentioned earlier is if you have a beneficiary who is someone who that has special needs, typically it's someone who's disabled, either Social Security certified disabled, or they might be received 2 letters from a doctor stating that they qualify as a disabled person. Then there are, the way to leave them property is through a special needs trust. And in Minnesota, we have 3 different types of special needs trust. I'm going to talk about the 2 that we would most commonly use within a plan. And the first would be a supplemental needs trust. A supplemental needs trust is a trust that is created for the benefit of a disabled person, and it's funded with third-party assets. And what I mean by that is that the property that's put into that trust is property that special needs beneficiary is not legally entitled to. So if it's the beneficiary's assets, it cannot go into the supplemental needs trust. If it's a settlement, or if they have already received an inheritance and it's an outright inheritance, it cannot be put into a supplemental needs trust. Assets that are in a supplemental needs trust are not counted for determining eligibility for government benefits, such as medical assistance, supplemental security income, Social Security disability, those different types of programs. So this is a way that it's called a supplemental needs trust because it is intended to supplement but not supplant the government benefits that the beneficiary may already be receiving. So if the person is receiving medical assistance benefits to pay for prescriptions or doctor's appointments or to provide assistance in paying for housing, then the funds that are in the supplemental needs trust could not be used to pay for those purposes. But it can be used to pay for other things to enhance that beneficiary's lifestyle. It can be used to take them on trips. It can be used to purchase an accessible vehicle for that beneficiary. A home is even something that can be purchased with a supplemental needs trust. So its intention is to enhance the lifestyle of that person without losing them their government benefits. The big difference with a supplemental needs trust compared to a regular special needs trust is that there is no payback provision for government benefits. So benefits, particularly medical assistance, has estate recovery. And what estate recovery is, if you receive medical assistance under certain programs, then the amount that the state paid out on your behalf can be claimed against your estate after your death. So they place a claim saying we paid out so much for Joe beneficiary, and we need to be paid back for those funds that were distributed. That cannot happen with a supplemental needs trust. A special needs trust is different because a special needs trust is funded with the assets of the disabled beneficiary. So this would be if the person already has gotten their inheritance because the planning wasn't done to give them a supplemental needs trust, then that special needs person could create a trust for themselves to put the funds into. And it's treated very similarly to those supplemental needs trusts, with the exception that the funds that are in the special needs trust, there is specifically needs to be a government payback provision in that special needs trust. So the funds go to pay that estate recovery claim after the death of the special needs beneficiary. I'd like to turn to estate taxes now. Estate taxes are things within each one of the different planning tools that we've talked about, the will or the revocable trust, that depending on the size of your estate, there may need to be provisions in your planning documents to try to save as much money for your heirs as you can. Estate taxes are taxes that are paid by an estate on assets that are held in the estate. So they are not an inheritance tax. The person receiving an inheritance doesn't pay taxes. It's paid by the estate before the assets are distributed to the estate beneficiaries. And what's taxed is called your taxable estate. And the taxable estate is all assets that are owned by the decedent, which is the deceased person, including life insurance. So life insurance, a lot of times when financial advisors talk about life insurance, they talk about it as a tax-free way of passing money on, but it is subject to estate taxes. It's just not subject to income taxes. So the death benefit in life insurance is included in your taxable estate, which sometimes can kick the value of your estate up higher than what you traditionally think of, because we don't usually think about getting the death benefit from life insurance because we won't see it if we're the one who's the insured. Another thing to know about estate taxes is that there is an unlimited marital deduction. And what that means is that for gifts or for estate taxes, if assets are passed to your spouse, if you are married, you can pass an unlimited amount to your spouse, and the spouse, and neither you nor your spouse has to pay taxes on that transfer. In Minnesota, we have what's called a clawback for estate taxes as well. And what that means is that if there are any gifts that are made within the 3 years preceding your death, the value of those gifts gets pulled back into your taxable estate. So this is a provision that was added by Minnesota law a few years ago, with the goal being to prevent deathbed gifting. Because in Minnesota, you used to be able to say, well, I'm going to give away everything that I have that would cause estate taxes. And then if I die the next day, I'm not going to have to pay the state of Minnesota anything. So they added this 3-year clawback in. There are 2 different levels of taxes. There's federal and there's state taxes. And the federal taxes is a combined estate and gift tax, and we call it a unified credit. As of the beginning of this year, the unified credit went up to $12,600,000, $60,000, excuse me. And what that is that's the amount that you can give away during your life, or the amount that you can have in your name at the time of your death without having to pay any taxes. If the total amount that you've given away during your lifetime, or the amount that you have in your name at the time of your death, exceeds that $12 million number, then you are taxed at a flat 40% rate. So it's a pretty big tax for the federal government. In addition to that $12 million unified credit, the federal government gives you an annual exclusion. And the annual exclusion just went up recently to $16,000. It was $15,000 for the past few years. The annual exclusion is the amount that you can give away per person per year without having to file a gift tax return. If you give over $16,000 to any given person in any given year, then you have to file a gift tax return. But you don't pay gift taxes until the total amount that you have given away through the course of your lifetime exceeds that $12 million number. The federal gift and estate tax sunsets in 2025. So what that means is that when the law was enacted to increase the estate tax for the federal government up to that $10 million number, what they did, the legislature said, when we get to 2025, this is going to go away, and we're going to go back to our previous numbers, which was around $5 million. There were a couple of proposals at the end of last year that were included in the Build Back Better Act to try to jumpstart to get that sunset to occur at the end of 2021, but nothing has been passed at this point. So I just call that out, because while we have that $12 million number, that might change as the federal government has a number of different proposals for changing the estate taxes. Minnesota's estate tax is $3 million. And that $3 million, if you exceed the $3 million number, then the estate tax rate depends on the size of your taxable estate. So we have tiered taxes depending on how much money you have, and it ranges anywhere from 13 to 16%. And Minnesota does not have a gift tax. A big thing to be aware of with estate taxes for Minnesota is portability. Portability is available in the federal government, and this is applicable if you are married. Portability is the ability to share your estate tax exemption with your spouse. And for estate taxes, for portability, for the federal government, if you have over that $12 million amount in your estate and your spouse passes away, and you file an estate tax return, you can elect to reserve any unused amount of your spouse's estate tax exemption. So if you're married, you have 24 million between you and your spouse with both of your estate tax exemptions. And if your spouse doesn't use all of theirs on their death, then you can save theirs and use it at the time of your death to pass double the estate tax amount for the federal government. Minnesota does not have portability. We have a use it or lose it system. And what that means is that if you use your marital deduction in Minnesota, meaning you say everything is going to go to my spouse and they're going to get it outright and they can do whatever they want to do with it, then you will lose your $3 million Minnesota exemption for estate taxes unless you have any other particular type of planning. So trust planning in Minnesota can be very essential to ensure that you're able to take advantage and use both $3 million estate tax exemptions to bring your estate tax bill as low as possible, depending on what your property is. Another thing that I want to talk about is retirement accounts. And I want to bring this up because there was a substantial change with how retirement accounts are treated after death at the beginning of 2020. When I refer to retirement accounts, I'm referring to income tax deferred accounts, so not Roth accounts, and the type of account where you take a distribution from it and you recognize income taxes on those funds. So traditional IRAs, qualified plans that you may receive from an employer, such as a 401k, a 403b, those different types of accounts. On those accounts in January of 2020, the federal government passed the Secure Act. And what the Secure Act did for retirement accounts, you may be familiar that when you hit a certain age, you have to start taking distributions. And that's called a required minimum distribution. Required minimum distributions are the amount that you have to take every year from those retirement accounts. And the amount of that distribution is calculated based on your life expectancy. The Secure Act increased the age for taking required minimum distributions to 72. It was 70 and a half. And the other thing that it did is it created what's called an eligible designated beneficiary. So what happened with retirement accounts is they created categories for how people inherit those accounts. It used to be that if you named a beneficiary on a retirement account, then that person could elect to take an inherited IRA, which then when they inherited those funds, if they were a non-spouse, they would immediately have to start taking required minimum distributions. And the amount of that required minimum distribution will be calculated based on their individual life expectancy. What they did now is they said if you are a non-eligible designated beneficiary, which is a mouthful of a term, you have 10 years after the date of death of the plan holder. And by the 10th year, you have to fully distribute all of the funds that are in that IRA. So what the federal government did is they accelerated the time frame for inherited IRAs to have to be fully distributed. If you are someone who is an eligible designated beneficiary, and I've got a list of who that is, spouse counts, or if you are a disabled or a chronically ill individual, a minor child, or a person who is not more than 10 years younger than the account owner, then you can take required minimum distributions based on your life expectancy. If there is no designated beneficiary on an IRA, then the account either has to be fully distributed within 5 years after the date of death of the account holder, or it would be distributed based on the life expectancy of the account holder if they were already taking required minimum distributions. So I just like to go through that because I think it's complicated and confusing, but I feel like it's one of those things, the more that you hear it, the more that you understand it. And it's important to know that retirement accounts are always a little bit different when it comes to estate planning. With retirement accounts, I also want to talk about charitable giving, because retirement accounts within an estate plan are a really great place to give to charity if you have charitable intentions. With retirement accounts, I've mentioned that there are taxes that are yet to be paid on that account. And with that account, anytime you take a distribution, you pay taxes on it. So if you name an individual beneficiary and they have to take the money out of that account, they're going to have to pay taxes under their same tax bracket. If they take out more money, it's going to result in them having to pay more taxes at a higher tax bracket. If you use a charitable beneficiary on your retirement accounts, charities don't pay income taxes. And so unlike the individual beneficiary, a charitable beneficiary gets a dollar for dollar benefit of the funds that they receive from a retirement account. The other thing that I want to mention about retirement accounts is what's called a qualified charitable distribution, or a QCD. A qualified charitable distribution is a way that you can protect against tax liabilities due to increased income. So what you are able to do with a qualified charitable distribution is, if you have to take a required minimum distribution from your IRA, you can direct that required minimum distribution straight to a charity and satisfy that RMD requirement, but do it in a way where it doesn't increase your income taxes. So it doesn't hit your tax return and push you up into a higher tax bracket. So it's a great way that you can, if you already have charitable goals, that you can direct that money that you already have to take out of your retirement accounts straight to the charity of your choosing. And then you get some tax benefits from it because it reduces your taxable income. It can reduce the amount in the future that you have to take for required minimum distributions from that account. It allows you to make a larger gift if you get that money and then you make a charitable contribution and you're taking a charitable deduction on your tax return. There's an AGI limit for how much you're able to take for that tax deduction, and you don't have that with a qualified charitable distribution. And it's good if you have a specific charity in mind. So if you have a donor advised fund, you can't do a qualified charitable distribution unless you specifically have the charities outlined. But I just want to mention that because I think it's a great way to reduce taxes. I'm running a little bit short on time here, so I'm going to quickly go through the incapacity planning information. And what this refers to is just if there is ever a period where you are alive, after your death, your trust or your will dictates who has the ability to control your property and where it's going to be distributed. While you're living, you have that control yourself. But there's a gray area where you are alive, but you're either physically or mentally incapacitated and you're not able to manage your own property. And part of any estate plan should include incapacity planning to make sure that we don't have to go through any kind of court procedure to get someone appointed to make decisions for you. A healthcare directive says who can make healthcare decisions for you if you're not able to do it yourself. You dictate who that person is that would make decisions, and then you give instructions about what your wishes are with respect to receiving healthcare. So you can say whether you want heroic measures, you can say whether you would like to be an organ donor, and all of those different types of things. Anytime I mention healthcare directives, I like to bring up Karen Quinlan and Terry Schiavo, which are names that we may all recognize, which are women that didn't have healthcare directives, and they were young. They were in their 20s and 30s. And when it came to making decisions about withdrawing life support treatment, their families were not in agreement about what would happen. And you can dictate that information in your healthcare directive and avoid having that become some type of process that would have to be decided in court. I also want to mention HIPAA waivers. HIPAA waivers are important because they give authorization to release your medical records. If you have a healthcare agent, they should have a HIPAA waiver so that they are able to get information about the medical decisions they may need to make about you. I also want to mention what a document that's called a POLST, Provider Orders for Life-Sustaining Treatment. This is a document that we most commonly see if people are residents in long-term care facilities or if they have diagnoses with terminal illnesses. This creates a standing medical orders for whether you want to be resuscitated, intubated, or for artificial administration of food or hydration. So if you, sometimes we'll have clients with terminal illnesses that if they were found unresponsive, they would not want to be resuscitated. And so it's important to have a POLST in place to allow that wish to be honored. If you have no healthcare directive, then the default is a guardianship proceeding with the court. The other document is a power of attorney. A power of attorney puts someone in place who can make financial and property decisions for you. And powers of attorney and healthcare directives, again, I believe everyone over the age of 18 should have these documents because they give you the ability to control who your substitute decision makers are going to be if a time arises where you can't make your own decisions rather than having a court have to make those choices. And to some, estate planning, there's no one size fits all estate plan that we create for people. It's everyone has different goals and everyone has different needs that they need fulfilled. And so it's important to sort of go through and talk about, we have all of these different documents and options for using within your estate plan, but we need to make sure that it's tailored for you specifically. And when we do planning, we look at living well to the very end, creating different options so that we're not using the court as the process for who is going to make decisions for us when we can't make our own decisions. We want to preserve autonomy. We want the client's wishes to be carried out with as little cost as possible and to preserve family harmony after you're gone. We don't want to create an estate plan that's going to trigger World War III amongst your family. We want to build a legacy. Planning is also about building a team and building trusted professionals. Your attorney, your CPA, your financial advisor, everybody should be in communication with one another to give you the best outcome and to know your values and make sure that your plan is going to carry out your values. And planning is about giving back to the ones that you love, making sure that you're able to leave a legacy and make tough times after you're gone easier for your family members so that they can just spend time grieving and thinking of better times. So with that, I just want to thank everyone and I will stop sharing my slides here and I can open it up if there are any questions.
I've got a question for you, Lauren, and it's back from the very beginning of your presentation. You talked about that will doesn't cover joint ownership. And then you talked about three things: an authorized signer, joint ownership, and I didn't catch the middle item.
I think what I said was the other way to give someone access to your account rather than having them listed as a joint owner would be to name them under a power of attorney. And I'm sorry, I know I glazed over the power of attorney piece of the presentation a little bit, but the power of attorney document says who can make financial decisions, what financial decisions they can make for you, and when the power to make financial decisions arises, and whether they have the ability to gift your property. So if you have a bank account and it's not in a trust, and you are incapacitated and someone needs to have access to pay your bills and make sure that things are still moving along, and if you've named them under the power of attorney, then they take that power of attorney document and give it to the financial institution. And then they are listed on the account as the person named under the power of attorney. So they don't have ownership of that account, but they do have the ability to control that asset for you.
Thank you. I also want to put in a quick message that Kelsey Crouch Dodson, who is on staff with Westminster, had to leave us a few minutes ago, but she has taken Mary Hess's position with estate giving. So if you've got any questions related to estate planning, especially with regards to the church, you can sure contact her. Other questions from anybody? And note that you are mute. Yes, Jane.
Thank you for all this great information, Lauren. Just real quick, I am divorced. When I pass away, I want my assets to go to my two sons. From what I understood you to say, it sounds like I need to set up an inherited trust for my heirs, I believe it's called.
Are your sons minors?
No, they are not.
Okay.
And then, is that the correct thing to do? And then how does all that change if I should get remarried?
So whether they would need inherited trusts would depend on whether you want them to get an outright inheritance from you where they can just put the money in their bank account, or whether there would need to be additional control over those assets. So if you updated your estate plan now, and then if you got remarried later, you would want to update it if you got married. So that's one of those life changes that you want to make sure that you update your estate plan to make sure that it's matching whatever your new goals are.
Yeah, I guess that's a big question I have, is that I do want a lot of my assets to go to my children.
Sure.
Rather than my potential spouse, because, for a lot of reasons.
Yep. And that would be another reason too, if you were to get remarried, to look at having a prenuptial agreement in place to ensure that if you want everything to go to your children, that agreement is in line with your estate planning wishes. And sometimes, depending on how much is being distributed to the children versus to the new spouse, we might do a consent by the new spouse saying that they acknowledge that they're not receiving everything that they might be entitled to and that they consent to that.
Okay.
So it's all about avoiding problems later when we do estate planning.
Right.
Thank you, Jane. And I see Nell, you've got your hand up.
Yes, I know this is hard to ballpark, but to do a trust, not a real complicated trust, but a trust nonetheless, can you give a ballpark of the range of cost? Or maybe you did that at the beginning, I came in late.
Sure. No, I didn't give that information. Anytime that we do planning, it depends on what your assets are, whether you're married, and then ultimately what your goals are, where you want everything to be distributed. So it's difficult to give a ballpark because it can be all over the place. Generally, we're looking at for trust planning, it could be anywhere from $1,500 to several thousand, and it depends on the complexity of the plan. When I work with clients on estate planning, we have an initial meeting, and during that meeting, we go through, here's all of your assets. We talk about your family in detail, so that I get a good idea of what family dynamics are and how you want things to pass on to your heirs and what your goals are. And then we talk about what different estate planning tools could be used to accomplish those goals. And then I'll usually give flat fees where I'll say, this is how much it would cost to do this. This is how much it would cost to do this different option, so that you have a good picture of what it would look like. For the initial meetings, we do charge. So we do hourly billing, but we usually roll that into the flat fee that we quote for whatever the estate planning recommendation would be.
Thank you.
Thank you. And Barbara Prince, you've got your hand up and you're on. Oh, you took yourself off mute.
Yeah.
Good.
Yeah. Thank you. I, a few years ago, was the sole owner of my condominium. And I decided I needed a will because of that property owned. And then I subsequently sold it. And now I wonder, I've got beneficiaries on everything else that would be useful, and I'm renting now. So it's like, I don't know what to do with that will. Is it something that really should be for some reason updated, or can you cancel them, or what happens?
If you have things in your will that are no longer what you want to have happen, then the will should be updated. I do think that everyone should have, even if you're using beneficiary designations to pass your assets on, it's always a good idea to at least have a simple will in place underlying those beneficiary designations, even if you never use it. And the reason for that is that if you did get an asset that had to go through probate, and it can happen. I've had clients that have been beneficiaries of estates and they died before they got their inheritance, and we had to do a probate so that they could collect that inheritance. It sounds unlikely, but it happens. But if you have a will, then if we have to probate your estate, then we're able to do that informal, unsupervised to make it as inexpensive as we possibly can. Whereas if you don't have a will, or if we have one that's not validly executed, it may require more costs for your administration. So to your question, Barbara, I would have your will reviewed and see if it's still accomplishing your goals. If it's not, then you may want to do an update, even if you're never going to use it because you have beneficiary designations.
And then then does a will automatically go into probate though? Because everything's been satisfied?
Yep, the assets go through probate. The will doesn't go through probate. So if you have, at the time of your death, everything's got beneficiaries listed, then you don't need to worry about having to use that will. It's not going to create a probate. It just protects where if you have assets that go through probate, it says how things are going to happen and allows them to happen inexpensively.
Great, thank you.
Yeah.
Okay, Kathleen Campbell. See your hand up. You're also muted. You may need to unmute yourself.
I'm sorry. So could you please explain again the regulation where 10 years after the date of death, the IRAs must be fully distributed. What does distributed mean in this context?
Sure. So if you are a non-eligible designated beneficiary, and that would be not the people that were on that listing. And one thing I want to mention is that the PowerPoints, I emailed a PDF to Sue, so that'll be available if anybody wants to get a copy of the slides. If you're a non-eligible designated beneficiary, so a child is the best example of someone who's a non-eligible designated beneficiary, and you are named on an IRA, and your parent passes away, then you can collect that account and transfer it into an inherited IRA, meaning that you're not going to pay all the income taxes at that time. But 10 years after the date of death of your parent, that account has to be fully distributed, meaning that you've taken the money out and you've put it into a non-IRA account and you've recognized the income taxes for having done that. So why that 10 years is important, or why that's a notable change, is because previously, inherited IRAs for children, they had to take those required minimum distributions. So every year they were taking money out of it until there was nothing left in it and there was no 10-year requirement. Now there's no requirement for a distribution every year. So if you inherit an IRA and you're a non-eligible designated beneficiary like a child, then you could conceivably end up in a situation where 10 years down the road, you've let this retirement account accumulate and you've taken no money out of it. And now you've got to take everything out in one tax year. So let's say that amount is, you inherited $150,000 and that grew and grew and grew for 10 years. And that 10th year, you're going to have to take all of that 150 plus whatever interest it accumulated, and you're going to recognize all of that as income in that tax year. So it's beneficial for people that are inheriting IRAs and are non-designated beneficiaries, non-eligible designated beneficiaries, to potentially schedule the distribution of that IRA over that 10-year time frame. So they're minimizing that tax hit.
Got it. Thank you.
Yep.
Does anyone else have questions? Yes, Scott. You're muted.
Thank you, Lauren. This, I've heard this kind of information a number of times, but I don't know that it's ever been as clear as how you presented it. So thank you so much. We have a trust and are glad that we do. An aspect that you talked about that I like a lot is the privacy aspect of not going through probate. But over the holidays, I was talking to a friend of ours and he was saying that probably a lot of people don't, so I want to get your response to this. A lot of people don't need a trust per se if they have, their beneficiaries listed correctly, and say if they've got that TODD, that transfer upon death of property. So how would you respond to that person?
I agree with him. Yeah.
Oh.
A trust is not for everybody. That's kind of why I made that Susie Orman comment, because, she advertises and she even sells a trust that people can download and use. And I never, ever, ever recommend that anybody do that, because it's not particular to your own personal estate plan and your own personal goals.
Mm-hmm.
Trusts are great if you have property in more than one state. And I say that particularly because if you do a will plan and you have property in multiple states, then you're going to have a very expensive administration because you have to have a probate in every single state where you have real property. So a trust is really great for circumstances like that, because all of those properties can be retitled into the name of your trust. And then you just have one trust administration, and we're not doing multiple probates. We don't need an attorney for every single different state that we have those assets in. The other time that trusts are great is for that privacy preservation. So if we have, complicated family dynamics where there's going to be a disagreement, or we have a family member that's being excluded, a trust is a good plan because if someone is going to try to contest what's in a trust, they don't automatically get a copy of it if they are not named as a beneficiary. If we have a will plan, then there's already going to be a filing in probate court, and that person that might be a problem beneficiary is going to get notice that, hey, here's the date that we're having this hearing to talk about the person's estate. And all they have to do is show up at that hearing and make an objection. And so it's much easier for someone to contest a will because they don't even have to hire an attorney to do that. We would hope that they would, but it can cause complications. Other things with trusts are just if you have really complicated distributions and if you have really complex ideas of what you want to have happen with your assets after you're gone, trust-based planning is just a much better way to do it if you have complicated goals that you want. But, to your friend's point, I'll share my parents themselves. We have wills and we have beneficiary designations because I'm an only child. And that's just the easiest way that we're going to administer their estate. We're using a transfer on death deed on their house. And we don't need anything more complicated than that because I'm not going to fight with myself as an only child.
Okay. Thank you. That's helpful. Yeah.
Sure.
Thank you. I do want to point out that Rachel put in the chat, but Rachel has sent a copy of Lauren's slides to everybody who registered on Realm. If you didn't register on Realm and would like the slides, just let either Rachel or I know and we will email them off to you. I want to thank you, Lauren, for a wonderful presentation. I know it went long, but that's all right. Are there any final questions before we go to Elaine? Okay, Elaine, you want to give us a few minutes on Meals on Wheels?
Yeah, great. Thank you so much. And thanks everybody for sticking around. I'll try to be brief here. I know a lot of you who are on this call. So, but for those of you who don't, I'm Elaine Wilson. I'm one of the co-chairs of the Hunger of Ministry team. And we've been approached with an opportunity that I wanted to share with all of you, and thinking that maybe some of you in this new year are thinking about ways to deepen your relationships with one another or deepen your faith through a service opportunity. Wanted to let you know about Meals on Wheels. So at the beginning of the pandemic, they had to do a lot of things differently. They cut back their deliveries to a couple of days a week. They went to not delivering hot meals, but delivering frozen or refrigerated meals. And now they're looking to go back to 5-day-a-week delivery with hot meals. And so they need a number of volunteers to help them do that. And so again, some of you may be familiar with Meals on Wheels, or you maybe have been a recipient of Meals on Wheels in the past, or one of your family members, but they deliver hot, now nutritious meals to people who are seniors or others who are unable to prepare meals for themselves. It could be longer term or it could be shorter term. And we partner with Community Emergency Services at Westminster to deliver meals in the downtown and near downtown areas. We currently have a team that delivers meals on Mondays. And as I said, deliveries were cut back during COVID. And so they're looking to expand and go back to hot meal delivery now. And the days of the week that they're expanding to are Tuesdays and Thursdays. So the opportunity is to either as an individual or as a team come together to be a cohort of volunteers to deliver meals on Tuesdays or Thursdays. It's a relatively, although it's a weekly commitment, it's not a very hard thing, and it doesn't take a long time, 60 to 90 minutes. You pick up the meals about 10:45, you deliver to 3 to 5 clients in the downtown or near downtown areas, and you're done. Often, like Westminster's other cohort, they deliver meals in pairs. First of all, it's more fun to go with another person. And then second of all, often they're delivering to buildings or neighborhoods where parking is a real challenge. So one person can stay with the car and the other person can deliver the meals. And then that particular group, the Monday group, to help foster community and deepen their faith, they gather for a brief time of fellowship after they're all done delivering the meals for the day. CES provides all the training. It's really, they have designed it to be as safe as it can possibly be for both the volunteers and for the clients, because these are clients who are perhaps at risk because of health issues. And so they want this to be as safe as possible. It's a contactless delivery. Everybody wears a mask, hand sanitizer. You before you get out of the car and go take the meals, you wipe your hands with hand sanitizer, etc. And all of the delivery volunteers undergo a background check, again, to be safe for those clients, to be safe for them. Like I said, it's pretty easy. It's a very fun thing to do. And in this time, it's actually one of the safest volunteer activities you can do, because you're in your car, maybe with one other person, you're wearing a mask, the contactless delivery, and it still allows you to make a real difference in someone's life. To the people who receive those meals, these are life-saving meals. So if you are interested in this, or if you need more information, you can email act@wpc-mpls.org, which is the church's email address. And you can also get to that from the Faith in Action part of Westminster's website. And submit an email that says, I want more information, or I'm really interested in the Meals on Wheels opportunity. Or you can contact me directly. My name is Elaine Wilson again. And my email address and phone number are listed on the slide. So I will take any questions that people have immediately, but I actually would encourage you to think amongst yourselves about whether there's a group of people you'd like to get to know better, or you think you already know them and you'd like to do something fun together or do some service project together. This would be a really excellent opportunity, and it's kind of the new year. We're all thinking about things we're going to do different in the new year. So thank you. And I'll take any questions that people have.
Thank you so much, Elaine. Anybody have questions for Elaine? Okay. I do want to let you know that next month we will have Dr. John Heinrich with us discussing love and relationships in the third age. That should be a fascinating discussion, talking about the complexities of love and relationships. March 16th, we will be a week later than normal. It'll be the 16th. And we will have Elena Simone Tyler talking about opportunities to serve our neighbors. And then in April, on the 13th, we will have Matt Skinner giving us an introduction to podcasts. So I thank you all for coming. Yes, Rachel.
I just want to say, for anyone interested in Elaine's proposition, her idea, her in doing what Elaine has given us the opportunity to do, let me know, and I'm happy to help draw those people together. I have a feeling that after we hear from Elena in March, everyone's going to be like, oh my gosh, and so it'd be great if we could kind of get ahead of the ball game a little bit and just go ahead and do this. I know that for me, and I imagine for lots of people who would receive meals, getting extra people contact in the winter is especially important. So it's just something to think about. It's a tough month for people. These next couple months are long and dark, and during the pandemic, even harder. So I know the need is real now, and I just want to kind of give an extra plug for that.
Thank you so much, Rachel. Any final questions or comments from anyone? Well, we have definitely gone long, so I want to thank you all so much for coming, and hope to see you next month. Bye.
Thank you.
Thank you. That was excellent. Thank you.